Right, good morning, Mr. Dunn. Just give me a second if you don't mind. Right, so... temperamental screams in this court. Right. Okay. Off you go.
May it please your lordships, I appear on behalf of Mr. Karatysz, who's the appellant. My learned friend Mr. Marvin, King's counsel, appears on behalf of SGI Legal, who are the solicitors, and my learned friend Mr. MacDonald, who is junior counsel in Belsner, and for the solicitors in that matter, attends here today. There was an email sent in relation to Mr. MacDonald's attendance yesterday after the session ended.
Yep. What's Mr. MacDonald appearing for?
Well, perhaps he can answer and I can answer when he's on.
My lord, I appreciate that my role is slightly unusual in that I have no formal standing. Your lordship kindly permitted me to attend today and address the court on any general matters at the directions hearing we had earlier this year.
That was when there was an issue about the overlap between the cases, but there's no issue now.
My lord, I can assure you I will be, if I speak at all, it'll be no longer than 5 or 10 minutes at a maximum.
Right. I mean, if you speak at all, you'll have to persuade us that you there is something you need to tell us.
Yes.
So bear that in mind first.
Yes, I can give a very brief, I won't give a preview, but just to say the only points I've raised are general points that affect Belsner and the general cohort of cases. And it's just so that the court has the full context before it, in case it hasn't been raised by Mr. Marvin. I've got no doubt that Mr. Marvin will cover everything that needs to be covered.
Well, let's.
But that's all I would address.
Okay. All right.
My lord, I won't take any time in dealing with that matter. Just to say that obviously Cam Legal are not a party. Law Society haven't intervened in this matter. And SGI Legal have leading counsel on their behalf. So
well, one would have thought that was enough, frankly. I'm not sure for myself what point of principle this case gives rise to that overlaps with what we were hearing earlier in the week. But
well, look, let's hear the argument.
Yes.
From both of you, and then we'll see whether Mr. MacDonald is still bursting to speak.
Thank you. So in terms of the timetable, your lordships will have seen that we propose that I have a maximum of an hour, Mr. Marvin, my only friend, has a maximum of an hour, and then there's half an hour for replies. That's obviously subject to any interjections that are made, and it may be that various parts of my argument can be skipped over, so I'm going to say an hour maximum. Your lordships will also no doubt be heartened by the limited bundles you have in front of you for today's hearing. So there's only 2 short bundles and then a short authorities bundle. This case is about essentially a simple question, but one with, I say, profound implications for particularly consumers of legal services. And it's this. When a statutory bill is delivered, what is the amount of that bill for the purposes of the 1/5 rule? And your lordships will be aware, of course, that the 1/5 rule in the Solicitors Act provides certainty in that if the client is able to reduce a bill by 20% or more, then they have the cost of the assessment. If they don't, then the solicitor does, subject to any special circumstances arguments. So, in this context, what the appellant essentially says is the client must have a clear and certain bill and must be able at the outset to make a decision or make a determination as to whether to have that bill assessed. And the problem, the appellant says, arises in this case, as it does in many other cases, and your lordships have seen the bill in Bellamy yesterday, although I'm not going to focus on that because obviously my learned friend has not. But if bills are not...
You're giving Mr. McDonald the opportunity to say stuff.
No, well, I was
you
about...
start talking about the bells.
And I immediately rode back.
Well, let's focus on this.
Indeed. My overarching point as to why it's important is that if solicitor bills are not clear, then clients are put at a disadvantage.
What I don't understand is I mean, that's all very well and fine, and don't really disagree with it. But if it is clear that there's nothing more to pay, then why does it matter whether the amount of the bill is £1,500 or £2,700 in this case? Okay.
Well, it does matter because in order to assess the success fee element, the profit or the base cost element needs to be assessed.
Where is the bill?
The bill is at the back of the supplemental bundle,
Yeah.
so the final page.
Well, the best place to find the bill is in a separate document called SGI Legal Claim Form, isn't it?
I have it at page 203, so the final 2 pages of the last of the supplemental.
Usually my bundle ends at 187.
Ah,
I know I've seen the bill somewhere, but
It's attached to the claim form. Just
yeah, I've got it.
I'd like you to repeat what you just said.
yes.
It matters because,
Well,
just slowly,
yes.
give me that submission.
If one looks at this bill,
No,
it's
it matters because you need to assess the success fee.
base. Yes. Because
What has that got to do with the price of tea? Just make the submission, can you, just clearly. It matters because you need to do what with the success fee?
Because if the client wishes to have an assessment of the success fee,
Because if the client wishes to have an assessment of the
Then-
success fee,
then they have to know what basic charges, base costs were,
what basic charges were,
the profit costs were, because the success fee is based on the profit cost figure.
but that's all sort of specific to personal injury cases and success fees and CFAs.
Yes,
The question of what the amount of the bill means has got nothing to do with that. The question of the amount of the bill must apply to every solicitor's bill of every kind.
well, the question of the amount of the bill must apply to every solicitor's bill. That your lordship, of course, is right. And as a principle, all solicitors' bills, statutory bills, must be clear and transparent on their face.
I think you're pushing it an open door there.
Yes. What the particular issue within these low-value MOJ portal claims is that the solicitor deducts the money for the balance or the deductions at the source, so they deduct it from the damages. So it's not like in a private or commercial matter where you come to the end of the matter and your solicitor gives you a bill, you look at it, and you either pay it or you object to it. Here, there's already been the deduction. So from
Well, there is in some cases. I mean, we have to decide this case so that it resolves any bill. I mean,
yes,
success fees are just one thing. What I'm puzzled by is you're saying that this question matters because if the client wishes to have an assessment of the success fee, they have to know what basic charges were because the success fee is charged on the basis of success fee or the profit cost. But I mean, that's not a reason. What I'm asking you is, why does it matter whether the amount of the bill is £1,500 or £2,700, so long as you know what it is?
Well, it does
Because
matter.
and the reason I say that is because if you'd got the bill and you'd read it properly, you would have known that the solicitor was demanding nothing, right? So, therefore, the reduction, the 1/5, logically, comes from, that you may achieve, the amount of money that the solicitor wanted to be paid for the work, and therefore the assessment, and deducting one from the other, the amount you get back. And logically, you should only get money back if you get more than 1/5 of what the solicitor wants to be paid, in this case, back. Isn't it?
Well, what the solicitor, therein, I say, lies the problem, because, firstly, I don't accept, with respect, the suggestion that anyone who looks at this bill will be able to work it out, and work out what it says.
Why not?
Well, for the first,
Just look at it. It says at
Yes.
the bottom, it's got all sorts of guff about basic charges and success fee
yes,
and disbursements, and it then says less money received on account from Viva 1,116, balance payable by the client paid.
well,
Balance payable by the client limited
Yes.
to X paid.
the regional cost judge in Sheffield found it a confusing bill.
I know he did, but I can't understand why he did.
Well, and even my learned friend in submissions very fairly before the regional cost judge accepted that it
Well,
was.
maybe he did, but it's
Nonsense.
not. It's not that unclear, is it? It says paid at the end of it.
So there is a line in the bill that's the signed line that says total, and there is a basic charges which are set out as £1,717. The amount that's said to be payable is £455.50.
That's
There-
said to be paid.
Said to be paid, but even theoretically that was payable but has now been paid from damages.
Yeah, but it
Well,
says
the total amount paid is the 1116 received from direct line plus 45550 balance payable. Am I looking at the right page?
Yes,
121 on the core bundle.
my lord, that is.
Yes. So that means
My lord, I'm so sorry. And I was concerned that my lord, the Chancellor, might be looking at the wrong document. That's the
breakdown.
That's what came after the claim.
Where is the bill?
No, I'm looking at it in the supplementary bundle at page 203.
Oh, my lord, you do have it. I was concerned when you said behind the claim form.
Yeah, the point that I was going to make is if you look at that document, which is pretty short,
Yes.
so.
you've
Which
got
page is it? 'Cause I wanna make
203
sure.
of the supplementary
203.
bundle is attached to the claim form.
Oh, right.
It says that the success fee, which is capped at 25% of damages,
Yes.
260.42 plus VAT of 52.08.
Yes.
Disbursements ATE premium 143. If you add those figures together, they amount to 455.50.
Yes.
And at the bottom it says balance payable by client limited 25% of damages plus ATE premium brackets paid.
Yes, my lord.
Could
that's
not be clearer.
what I'm through.
So in that,
The amount that is, as it were, the balance that the client was going to
That's
pay has
the
already
bottom
been
line.
paid.
But what Mr. Justice Lavender did say very fairly is that we don't total the two bottom figures.
Well, I understand that.
And
point.
perhaps
You
with
could-
hindsight it would have been
could,
better.
It could be put in a different way, but
Well, look, let's let
Well,
Mr. Dunn. Let's just let Mr. Dunn develop his argument. I mean, you've heard that we, two of us anyway, seem to think it's clearer than the district judge did.
yes.
For my part, I sort of get that it could be clearer. But I don't understand why it's not sufficiently clear, since the document does not on its face ask for any money beyond 1116 and the 45550, which is paid.
Well, that is part of the problem in itself, because what Mr. Justice Lavender does find is that it's a demand for payment, but it clearly isn't a demand for payment. But if one, it is in my submission difficult if one is sophisticated lawyer who is used to seeing these sorts of documents to put oneself in the place of a lay client who's looking at this. Now, if the solicitor was saying to this court, the amount of this bill is £455.50, and that is the amount of the bill for the purposes of the 1/5 rule, because that is the amount that we have demanded to be paid and has been paid. That would be an argument that they could have put, but they don't put that. What they say is that the client has to go through and essentially take all this into account, add up the various parts, and come to a figure which is not contained within this bill.
Well, that's a different point. In that sense, the bill is unclear because the total that is the amount of the bill is not stated. But can I ask you this? The solicitors said that the proper question to ask to find out the amount of the bill is what sum is demanded by the bill.
Yes.
You say in your skeleton, the proper question to ask is what is the totality of the bill which the court is required to assess?
Yes.
I would like to put to you that a clearer way of assessing the amount of the bill, bearing in mind that the whole purpose of it is to work out whether you won or lost, is what is the total sum that the bill is demanding to be paid to the solicitors, whether or not all or part of that total sum has actually been paid. In other words, what is the total sum that the solicitors want to get out of this case?
Yes.
So that you can then tell if it's assessed at below that, whether or not the 1/5 rule applies.
So that, my lord.
Why is that not logical?
Well, that my lord, would require obviously the £455.50 to be in play, because that is the sum the solicitor requires to be paid. It would then, there's a question mark as to whether the monies received inter partes would also be included in that figure. But there is a problem here in my submission, because these bills, or this bill, not these bills, this bill seeks to justify this success with £260.42. It cannot justify that figure on the figures of monies received from Aviva, the inter partes money, because the money received from Aviva, the insurer, is the fixed costs. So the bill, if the bill only includes the 1116 and the 45550, that in itself can't justify the deduction.
Well, this is a strange case on that basis, because Aviva paid £300 more than fixed costs.
But that's for disbursements as well.
No, they paid £300 more than fixed costs because they paid for the preparation of stage 3 proceedings.
But they weren't ultimately.
And they weren't ultimately issued.
Yes.
And so this is not a case where Aviva only paid base fixed costs.
Yes.
Aviva paid more. And so that complicates your suggestion that there has to be some fixed rule about to calculate the success fee. I mean, the bill needs to state what sum the solicitors want to be paid or have been paid, because it has to work before the event and after the event.
Yes.
In the commercial case, the solicitor sends a bill for £10,000
Yes.
and says, please pay £10,000. And the client has a heart attack and says, I'm going to have that bill assessed, it's too much.
Yes.
That has to work. It has to be clear, it's £10,000 and exactly that. And in the after the event case, it has to be clear we've been paid £1,000 by one person, we've been paid £500 by another person, and we want to be paid in total £1,500. We justify this, we say we can keep the £1,500.
Yes.
And then if you reduce it and you get it down to £1,200, you'll get your costs, and if you only get it down to £1,300, you won't.
But that is not, in my respect for submission, that is not the situation with this bill, because if the constituent elements of the bill, if this bill was only the last two lines of the table, then the solicitors could not justify their success fee. Because the success fee on the fixed costs is lower than the success fee charged.
I don't understand that. I don't understand that submission. I'm sorry. I'm being very stupid. The way I read this bill
Yes.
is our basic charges are £1,717. I'm going to ignore the disbursements and the VAT. We're entitled, under our contract review, to charge a success fee of 100%. So that's another 1,717.
Yes.
But it's capped. In fact, we know it's capped by statute. And the amount it's capped at is 260. You add together those two sums, it's 1977.
Yeah.
Of that, we've had 1116 from somebody else.
Yes.
Doesn't matter what it's paid in respect of. We've had 1116. And that would normally mean we've got 860 we could still claim from you, but we're not claiming 860 from you. We're only claiming 455. That's because we've imposed, whether by contract or voluntarily, I don't know, a cap on the overall balance payable to 25% of your damages plus the ATE premium. So we're only claiming from you 455.50 of the 800 odd we could claim, and you've already paid it. Now, what is? Have I misunderstood what it says?
In order to my lord.
So why do you need to know, in order to justify the £260.42? Why do you need to know what the basic charges are?
Because if the basic charges are a lot lower than that.
Suppose they were 800, you'd still charge £260.42. Because you'd still charge 100% of your basic charges, capped at 25% of your damages.
Well, no, you wouldn't, because of the Herbert decision. Means
So you might only charge 15%, but it doesn't matter, either to the solicitor or to the client, whether a pound is a success fee or basic costs. It's just money.
No, it does matter for
Why
the
does it
purposes
matter?
of the 1/5 rule, because the Solicitors Act at 70(6) allows a client to either assess disbursements or assess base costs, so to carve out the various elements of the bill for the purposes of the 1/5 rule. So it is important that a client understands how that deduction is made up. It's imperative that they do.
What?
But if I could, my lord...
Why if the client's paid it? Why if the point... What this is all about is whether it's right that, because this has all been paid, your client got nothing out of this assessment. Nothing at all. That's what this case is about.
Well, that's... The client didn't...
Other cases may be about something else, but this case is about the fact that because perhaps not as clearly as it might have done, this said that everything had been paid. When it came to this assessment, your client came out of it with absolutely nothing at all.
Well, that is
It's got nothing to do with the 1/5 rule. It's a complete loss.
That's my lord, a different point to do with the special circumstances argument. The fundamental point is whether this bill, what the amount of this bill for the purposes of the 1/5 rule, and my lord, Lord Nugee's point can be developed because my lord says, well, it doesn't matter the 1717. It doesn't matter what that is made up of, but it does. So, if, for example, if that figure was £800, that base cost figure was £800, then the success fee at 15% would be £120. It wouldn't be £260.42, and so on and so forth.
I don't understand that argument because the success fee is 25% capped at 25% of the damages.
Yes.
The damages that were recovered from Direct Line, or Viva,
Yes.
same people, I suppose, was 1,250. And if you take the two figures of the 260.42 and the VAT, it's 312.50, which is 25% of 12.50.
But that's because it is a cap on the deduction. It is not the overall deduction. This is not a damages-based agreement.
No, but on
Where
the
they
other
say-
hand, the point is that's how you get to the calculation of the 312.50 plus the 143.
But that is the point. If this is a damages-based agreement, then the solicitors are entitled to charge 25%, no matter what happens. That is not the case here. Now, in reality, that tends to be the case. But the 25% is a cap. It's the absolute maximum. they can
But
charge.
what is it in this bill, as drawn,
Yes.
that prevents your clients from arguing, by which I mean checkmylegalfees.com, because that's what this is all about,
Well, it's
or
about
firms like
disparities.
them, from arguing whatever they want to argue about what the rates ought to be.
Well, nothing if I'm right about the total of the bill. But if we get, this is a fundamental point, and it may not have, it's possibly my fault for not putting this as succinctly in the skeleton, but this is a fundamental point. The cap is a cap, it is not a DBA. So that is the maximum. The figure of basic charges is put here at 1717, and it's put there to ensure that essentially the solicitor can charge the 25% in my submission. If the basic costs were, for example, £1,000, then the success fee would be £150. So this isn't a DBA style 25%. This is a cap. And if the base costs go down, or if they are seen to be unreasonable at 1717, then the success fee goes down.
Well, why does it, I mean, just because 15% is what it said in Herbert, what's that got to do with the law? I mean, they may realise that it'll be assessed down, but they're entitled to charge contractually a success fee of 25% of damages.
No, my lord, contractually, they're entitled to charge up to 100%.
Yes,
success
exactly.
fee.
And
But capped
under the
at 20%.
cap, they're only entitled to charge 25%.
But the Court of Appeal have said, in these modest road traffic accidents, unless there is an individualised risk assessment, which can justify a success fee of far higher, that a lower success fee is reasonable. And the result of that is that in this case, as in the other cases we've seen, 15% is accepted as
Well,
reasonable.
You see, this is very confusing.
Well,
We are dealing with the question of words in a statute which apply to every kind of case, personal injury and every other. And you just told us, for example, that section 70 subsection 6
yes.
allows the assessment of disbursements and costs, basic costs. But actually, it doesn't. It says the court under this section may order the assessment of all the costs,
Yes.
all of the profit costs, all of the costs other than profit costs, and where part of the costs is not to be assessed, may allow an action to be commenced or continued for that part of the costs.
Yes.
Now,
That's
what
the-
it's saying is the assessment is what we are, of the bit you asked to be assessed,
Yeah.
is what we are concerned with. And that has a bearing on the meaning of section 9, which says, unless certain conditions apply which don't matter, that A and B, the costs shall be paid according to the event of the assessment, and that is to say the amount of the bill is reduced by 1/5.
Yes.
And what it means is the amount of the bill for the bit that is to be assessed.
Yes, my lord. That's right. Yes.
Now-
That's right.
What happened here was did they ask to assess only the base cost?
The basic cost, yes, and the
Not the
success fee.
And the success.
Yes.
That's the point.
Yes, because one as I've said, one has to assess the basic costs in order to get to the success fee. Because if these basic costs are reduced, as I say, down to £1,000, the success fee that the client has to pay will be reduced accordingly.
Yes.
And the reason 100%, you see, 100% of the basic charges and the figure of 1717 works out to mean that the cap won't be excluded, it won't be gone over. But if one then looks at what a reasonable success fee is, and in this case, a reasonable success fee was accepted by the solicitors to be 15%, and then one looks at whether those basic charges...
It's 15% of damages.
Of basic charges.
The statutory cap is 25%
Of damages.
damages.
Yes. So, and this is unfortunate, as is often the case with the lowest value, the rules aren't as easy to grasp as they should be. But the success fee can be anything up to 100%. But there is a statutory cap
You have to say of what?
of 25%
No, but you
of
have
general
to say
damages
of what,
and
because
past losses.
It seems to vary second by second, and everybody has to understand what you're talking about.
Success fee
The success fee can vary.
can be 100%, up to 100% of basic charges.
Yeah.
Subject to statutory cap of 25% of general damages and past losses. So the client, when they see this bill,
And
needs...
just to interrupt,
Yes,
for most of these small road traffic accidents, there aren't any future losses. I mean, it's mostly your damages.
yeah,
It's pain and suffering
Yes.
for a short, nasty period, but you recover from it.
yes, there will be, I mean, there would be outliers, but for the most part, if there was future losses, it would be over the £25,000.
Yes.
I mean, there may be some actually within the £10,000 to £25,000.
Okay, we don't need to worry.
So the client, when they see a statutory bill, will need to ask a number of questions. They will need to ask whether the success fee percentage is fair and reasonable. So in this case, is 100% reasonable? They then need to ask whether the basic charges charged are reasonable. And your lordships will recall from this week, in these cases, we're talking about basic charges in a fixed cost regime inter partes. So, is over £1,700 for the work in this matter reasonable? If either of those two, the percentage success fee or the basic charges, if either of those two are not reasonable, then they can be assessed. And they can be assessed down, which will result in that 45550 figure being reduced.
Why?
Because
That's the problem, because the 45550 figure doesn't necessarily get reduced. Does it?
yes, well, using my example of the base costs in this case being assessed at £1,000, and then that would result in a 15% success fee of £150.
Yes.
So
Base cost 1,000.
base costs are assessed at 1,000
Success fee 150.
of 150, so 15%, which was agreed between the parties as reasonable.
When was that agreed?
That was
It was agreed. It was assessed by. It was assessed by the district judge, and it wasn't appealed.
no. I'm grateful to my learned friend. Yes, it was assessed by the district.
So we now got 1150.
Yes, we're at 1150, and so the element which is payable is the £150, the success fee, plus the ATE premium, which is £143.
So you're going too fast.
My apologies.
If the base cost is £1,000,
Yes,
the success fee is 15% of that, which is £150.
yes.
Yes, then
So the amount payable by the client would be £150 success fee, plus,
The client pays VAT,
yes,
so that's another £30. That's £180.
yes,
yeah, keep going.
And the client pays the ATE premium, which is £143.50.
yes.
Presumably, I don't have to pay VAT on that.
No, there's IP insurance tax, which I think is included in that.
Is included. Right.
ATE of how much?
AT is £143.
And then
Yeah.
43.
That gets you up to 32350.
Yeah.
Yep.
So that would produce a figure, a balance payable of 32350.
But that assumes that the client can't be asked to pay anything more by way of base costs than what's recovered from the other side. But why do you make that assumption?
Because that's what that's what this bill clearly states.
Where does it state that?
Because that's how it's calculated by well, it isn't clear how it's calculated, I have to say, because it's not clear how that 45550 is made up. But if one takes,
You see, the 1116 received on account from Aviva, we know, is in fact made up of disbursements.
yes, yes, it is clear that that's what this bill says, because if one adds up the 260.42, the success fee only, plus the VAT on that success fee,
You haven't put the VAT on the base costs.
plus
Yeah.
the 2660.42, which is in the column of costs, not VAT, then the VAT on that, which is 52.08, then the 143, that is 45550.
Yeah.
Well, that's how they in fact calculate it, but that's not the question. The question is, if you tax the bill, assess the bill down,
Yes.
what remains payable by the client? That's the question, isn't it?
Well, for a statutory bill, the question is, what does the bill say? The solicitors cannot deliver a statutory bill and then at a later date say, but we could have charged you X, Y, Z. They are bound by their statutory bill. There are very few exceptions where one can amend a statutory bill, but I think as a general proposition, it's accepted. It will be accepted that one is bound by your statutory bill.
Okay, my understanding of what Aviva paid,
Yes.
which I'm taking from paragraph 14 of the judge's judgment, is they paid £300 plus VAT, another £300 and £200 plus VAT.
Yes.
So they have paid £800 plus VAT. The
Yes.
base costs on yours has gone for 1,000. So why can't the client be asked for another £200 plus VAT? It's another £280.
Because the client can only the amount that the solicitors are charging is only on the basis of the statutory bill that's delivered.
Yes, and what they've said is the total amount payable is 1977.42
Yes.
plus 323 for disbursements plus 431.48 for VAT. As the judge points out, they don't actually total that up, but if you do total that up, it comes to something over £2,600.
Yes.
And then they've said, we've had 1,116 from Aviva, we know how that was in fact made up, but it doesn't matter, it's just money. And then they say, the balance payable is 455.50. Again, we know in fact how that was made up. We do
Yes.
now we've seen the breakdown. But it doesn't matter. What the solicitors are saying is, we were entitled altogether to £2,700. We've had 1,116. We're claiming another 455, which you've paid. And so,
Because it came out of the damages.
why is there?
But my lord, that
Even
is-
if you tax the base cost down to 1,000,
Yes.
you rewrite all the figures, they'd still be entitled to 455 because they still wouldn't have had all the money which they would be entitled
But
to charge.
in your lordship's example, the total of the bill is in fact the real total of the bill, because what your lordship is saying is that is the amount that they're entitled to charge.
Why are the solicitors not entitled to say, our basic charges on a time basis, as agreed with you, at the rates agreed with you, are 1,717 plus VAT. That is what we were legally entitled to recover from you. The success fee, which we're legally entitled to recover for you, is what is written there because of the cap, and that's the most we can get. We're entitled to the medical report and ATA premium as disbursements, and that comes to £2,600. Right?
Yes.
That is the amount that, if all other things were equal, we would be charging. But just as in Carthew, we happen to have been paid at 1,116, which might be calculated in a good way or a bad way or a difficult way or an easy way or an uncertain way. In this case, it's strange because they paid an extra 300 quid plus VAT they didn't have to pay. So it's not absolutely clear what it is. And the last line of the bill says, this is what we were entitled to charge, but we have agreed to reduce that bill to £455 as being the only amount we want you to pay. Now, what are the consequences if that then, and then you go to taxation, and the on assessment, the cost judge says, yeah, that's right, you were entitled to charge 1116 plus 455.50, so section 7010 means you didn't succeed and you have to pay the costs. Why is that in some way outside, as you say in your skeleton, the rationale of the regime, when it seems to me to be, as my lord puts it, all about the money? And the question is, did you get money back that you had paid, or did you have to pay extra money that you didn't have to pay, up to 1/5? So why doesn't that work?
Well, my lord,
Why are you not allowed to say, I could have charged £100, but I'm charging £50, I've been paid the £50, and that sets the client the task of getting the £50 reduced to £30 if they want to get the cost?
well, my lord, the answer I submit is that it is not all about the money. It is all about whether a client wants to have an assessment of the statutory bill.
Well, they know what this bill makes it perfectly clear.
Well, unfortunately, it doesn't, because if either the £455.50 is the success fee and the ATE together,
Yeah.
either it's that, or the £455.50 is a combination of items which we don't know about, but is the amount that they have chosen to charge the client.
But it's not though, because it says in terms what it is. It says in terms that it is the 25% damages as a success fee, which is explained further up the page, plus the ATE premium, which we know is 143. And you know, any client who if they couldn't add up for themselves, they'd use a calculator on their mobile phone, and you'd work out that was 455.50. Those two figures.
And so,
And also that they're saying that this was the balance that was payable beyond the 1116, and it's been paid.
so the client has received this and has been able to work out what is ultimately been taken out of damages, has undertaken the maths, and is left with, which isn't spelt out, but is left with the conclusion that £455.50 is the figure, is the key figure. The client then, so
It's not the key figure.
well,
I mean, the key figure of a bill
yes,
of costs from a solicitor
yes,
is how much the solicitor requires to be paid. It can be paid by the mother of the client or the grandparents or the insurer of somebody else or a friend or the government. Who knows? What the bill is to state is how much the solicitor requires to have put into the solicitor's pocket for the work that he's done in this case, plus his disbursements.
well, this bill,
Surely.
I would.
I mean, do you disagree with that?
I would put it in a slightly different way and say the key question for the client is A, what has been charged, and B, is what has been charged reasonable?
Yeah, but that's not even what you say in your skeleton. You say that the proper question is what is the totality of the bill which is the court required to assess? And in a sense, I agree with that. I mean, I disagree actually with the formulation, but I quite understand that that the assessment process is going to say, is the amount of £1,500 that the solicitor's put in his pocket a reasonable amount, a fair amount, and if not, how much do I have to give back? So when you say, what is the totality of the bill which the court is required to assess, the answer here is 1,500, whatever it is, £1,600.
1571.
No.
1571.
My lord, it isn't that figure.
Well, I know you say it
In my respectful submission, because if it is the 15, if I can just use the shorthand, if it is the £1,500 figure, how does the court assess whether the success fee of 15 if the court determines that the success fee should be 15?
That's the court's problem. I mean, that is not.
But the court will have to.
Can I suggest to you that the way the court does it is what the court did, looks at the base costs and says, which is 1,700, are those too high? What's a reasonable figure for base costs? It then calculates the success fee. What's a reasonable percentage? 15%. Calculates the percentage of that. It then looks at how much has already been paid, and it looks at how much more is either due back to the client or due from the client, given the way in which the solicitors kept the costs. And if the result of the first exercise is that the total amount payable by the client is no greater and no less than it was originally, then despite the fact that elements have come down, the overall bill has not. What's wrong with that way?
But I wouldn't push against that formulation of the assessment process. But that formulation of the assessment process, in my submission, highlights the fact that the £1,717, which is the basic costs, which my Lord Nugee stated at the start would be the first task. Are those basic costs reasonable? That's what the assessment does. Well, that shows quite clearly that this is an assessment of a bill which contains basic costs of £1,717. Those costs are specifically assessed by the court. But what the solicitors say is, although those costs form part of this statutory bill, and although those costs are assessed by the court, and the court will hear arguments as to their reasonableness, they say, but one should discount them for the purposes of the 1/5 rule.
Yes, because the 1/5 rule has any element that goes into the calculation of the amount payable being reduced by 1/5, but has the amount of the bill being reduced by 1/5. So you have to ask what the amount of the bill is. And the fact that in working out what the solicitors are entitled to after assessment, you look at it element by element, I don't see how else you could do it, doesn't mean that the amount of the bill, which is the overall amount the solicitors are charging, as my Lord Master Earl says, has been reduced.
If the basic cost element is not part of the question, what is the amount of the bill?
But if this
then
bill
how can
had
it be
said,
assessed?
if this bill had said, where you got the total,
Yes.
197742 and I think those are disbursements, aren't they? If it had said underneath that, there'd been a notation under that saying this is the amount that we could have charged, but we're not going to charge you that. All you're going to be charged is 1116 and 45550, and that's already paid.
My Lord, it's not the amount that they could have charged. It's the amount they did charge for the purpose of the success fee calculation.
But they didn't
No,
charge
they
it.
didn't
They didn't charge it. They
amount they
calculated
could have
it. So
Well, it's basic charges, and it's said, and that is how the success fee is calculated.
Yeah, because that's the amount. Its success fee is on the basis of 15% of the recoverable
Yes.
costs. That what could have been recovered.
The claimed.
It's the same
costs.
point as we had yesterday.
It's
What
the.
could have been recovered is not the same as what's being charged. Because the whole point is that these solicitors, their business model is, I could have charged you £2,500, but for whatever reason, I'm only charging you 1,700 or 1,500 or whatever. So if you ask what is the amount of the bill, What is the money the solicitor wants? The answer to that question is 1,500 quid, and he's had it.
It is. I would submit.
Or 1571, whatever.
It is not a question of saying we could have charged £1,717, but we didn't. That's not right, because they do charge it for the purpose of calculation of the success fee.
Yes, but they don't charge it for the purpose of what the client is asked to pay.
Well, in terms of the success fee, they do.
Can I just
They do
cut
in terms
through
of-
this for a second?
Yes, of course.
Seems to me you're arguing and answering two different questions. My lords are berating you, if I can put it in that neutral way, about whether or not this bill asks for more money than was really they wanted to be paid.
Yes.
And I think we've had that argument. I mean, it seems that we all think that it only asks for 1,570, and that's what it wanted to be paid, and that's that. But your point, I think, is a different one. I think your point is the process of assessment cannot be conducted on the basis that the basic charges of the solicitors are unknown.
Yes.
And on my analysis and my lord's analysis, you say, well, the bill would then, on your analysis, be perfectly satisfactory if it had simply said basic charges and success fee £1,577, paid half by Aviva and half by BAD, but half by the client by deduction from the damages, and Bob's your uncle. You say, well, that's does not enable the court to tax the bill because it doesn't know what those charges are. The court is not permitted to impose findings of what is a reasonable rate when the solicitor hasn't said, and the process of taxation can't work. So you say a bill which says I could charge £10,000, but I'm only charging you £1,000, is to be regarded as a bill of £10,000. That's what we see in the cases. Whereas the cases don't say that. The cases say if it's perfectly clear that you only want to charge £1,000, the bill is for £1,000. If it's not clear, and you're saying I'll take £1,000 if you pay me this week, then that's a conditional bill and it's for the bigger amount. That's the way I interpret the cases.
Yeah, I would submit that Reed Paul is slightly different because with Reed Paul, the solicitor explicitly said, I've never intended to charge anything more than the bill.
Well, we could debate.
We can debate that, but I mean, it's perfectly obvious to me that the amount of the bill is only reduced from the charges stated if they say, we are not charging you anymore, full stop. We don't want any more, we're not charging you anymore, that's it.
Yes.
Now, the question then is whether you're right, and at the moment you're meeting some resistance, but I do see the argument that there has to be a statement of the way you get to the reduced bill, otherwise the assessment process can't be conducted.
Well, in the hallowed phrase, your lordship puts it much better than I. Yes, that is the point. The point here is even more so because what we have in that example of here's my bill for 10,000, but I will but say 1,000. We don't have the added complication of the court's task, which is to assess a success fee, which by definition it has to assess on the basis of the basic charges. If this bill had simply said, we're going to limit to £800, no success fee, you need to pay for the ATE, then obviously that's fine, because the court on any assessment wouldn't have to go any further. But if a bill is saying our basic charges are X this is how we calculate a success fee, then the court has to assess all of that. And subject to, and I accept it, subject to a special circumstances argument, the 1/5 rule bites at that point.
Yeah, but aren't you aren't you making the wrong argument, really?
Possibly.
Aren't you really saying the bill should and must, I don't know, we'll have to look at section 70 in more detail, must show how the working out as to how you got, particularly where there's a success fee, actually it doesn't need to in any other case, but it does need to do that, otherwise it can't be assessed. It must also state how much is being demanded. I mean, I use that as shorthand, how much money they want to put into their pockets or keep in their pockets.
Yes.
So those two things are essential for a statutory bill. Now, can we look at section 70 and see whether section 70 says that?
Well, section 69 of the Act unfortunately doesn't give us much assistance at all as to what a bill should contain.
Right, can we just look at section 69? I'm assuming it'll be in the authorities bundle.
I'm hopeful it is.
It is.
120.
Got away with this by a whisker, Mr. Darling.
Right.
So page 120.
Yeah.
Page 120, my lord.
Of the authorities.
I'm hoping that the pages match up.
So no action should be brought to recover any costs due to a solicitor before the expiration of 1 month from the date on which a bill of those costs is delivered in accordance with the requirements mentioned in subsection 2, and the rest doesn't matter. The requirements are that the bill must be signed and delivered in accordance with C. A bill is signed if it's signed and delivered if it's delivered to the party, it's delivered, blah, blah. Well, it doesn't say anything.
No, it's been, the requirements for a statutory bill have been developed through the case law over many, many years.
Right, and where is the case that says the bill has to show how your charges are calculated?
Well, in my submission, the proposition is that a bill must be reasonably complete and it must be capable of being assessed. So those are two.
Well, where do you get those from, please?
There's case law to that effect, which.
Yes, no, I need the case law.
Yes.
Because we're going to have to give judgments about all this. Bill must be reasonably complete.
So that's the case of Cobbett. Cobbett. C-O-B-B-E-T-T.
Yes, that's in the bundle.
That's in the bundle. Cobbett and Wood.
And it must be reasonably complete in what?
And be capable of assessment.
Well, that seems to be the critical point for your argument. Where's capable of assessment?
My lords, there is a case called Gwilym, which isn't in your lordship's bundle because there's no dispute that the bill was a statute bill. And so I speak without it in front of me, but it essentially says that the bill has to have enough information that the client knows in respect of what he's being asked to pay. But historically, although these days most bills do have some detail, under the Solicitors Act, historically there's been a distinction between detailed bills and gross sum bills. And in theory, at least, the solicitor can put in a bill saying a professional service is rendered between X date and Y date, £10,000. And the answer to how an assessment works is that the first thing that happens in an assessment is the solicitor has to give a breakdown. So the bill, and incidentally, the breakdown can be and often is higher than the bill. If the solicitor bills for £9,000, whether or not the solicitor tells the client that's a discount, the client doesn't like the 9,000, but the solicitor actually has 10,000 on the clock. The solicitor can put all 10,000 in the breakdown, and the court will work through all £10,000 of costs. And it's only if the client gets £1,000 off that he will get a penny off the bill.
And presumably the breakdown at the end says that amounts to 10,000, but our claim is limited to 9,000.
Well, it doesn't need to say that because it's always understood that the bill can't be increased on an assessment.
And where is the breakdown
Page
required under-
119 of
Page 119.
Sorry,
Of the
no,
core
it's-
bundle.
Sorry, not my question.
That's-
Where is the breakdown required in the rules?
It's rule 4610 on page 1632 of the White Book. 4610. I know your lordships have looked at 46.9. I don't know if your lordships have seen 4610. But this is the procedural bit.
Okay.
Okay.
I think we'll just go back to Mr. Dunn, but we'll just have a quick look at
Let's
that.
just have a look at 4610.
Yes. 4610, just to assist, is the standard directions that the court gives on a solicitor client assessment.
And,
So what happened?
The breakdown comes
the
well
procedure.
after.
The procedure is the client starts proceedings.
Either side can start proceedings, but in most cases, the client begins.
Client starts proceedings saying, I want my bill assessed. And at that stage, the solicitor delivers a statute bill, or has that already happened?
No, if there's a bill if a statutory bill has been delivered, then the client can apply for assessment at that stage. If one hasn't been delivered, then the client can request one is delivered and can make an application for delivery up under section 68 of the Act.
So
Right.
just so we understand the sequence here,
Yes.
your clients asked for a statute bill. They got the document which we've been looking at,
Yes.
that's attached to the claim form. They then went to the cost judge, who made an order for an assessment.
Yes, Part 8 claim.
They must have issued a Part 8 claim.
Part
Issue a Part 8 claim, the claim form, and then they get an order from the district judge for an assessment.
Yes.
And then under 4610(2), the solicitors served within 28 days the document which we've got at page 119 to 121
Yes.
of the core bundle.
That's right. There doesn't always need to be a breakdown because often some bills are complete enough that the court can assess them.
And
So I'm looking at page 80 of the supplementary bundle,
Yes.
which is the district judge's initial order, 11th of April, and he orders an assessment identifying the bill
And the amount of the bill.
and the amount, but it's limited to the amounts in dispute. It says the success fee, but that can't be right. It must mean the profit costs in the sum of 1977.42.
So which page are you at?
Page 80 of the supplementary bundle. And then it orders a breakdown. So we can see from paragraph 1 that the disbursements weren't in issue.
No, that's right.
And then we can see from paragraph 3 that that's in accordance with 4610 we've just looked at.
Yes.
Yeah.
That there's an order for a breakdown, and then we get the document which is the breakdown, which is at the back of the core bundle. Thank you.
So
And then you go on to points of dispute and points of reply.
that's right. There are a couple of important points about the relationship between the bill and the breakdown, some of which is dealt with in the cases that the learned judge referred to, but which isn't, which I say is not at issue here. The first point is that the breakdown comes at a later date, as can be seen.
Of course.
So, for the client, the breakdown is no part of the determination of whether to have the bill assessed or not. The second point is that the bill service of the statutory bill starts the timescales under the Act, and so once the bill is delivered, the client is not able to think to herself, well, I'll get a breakdown at some point and then I'll be able to decide what to do.
No, get that all together.
Mm.
But you've only got one point, really, Mr. Dunn.
Well, I hope it's a good one then.
And, well, you will. But and the one point is you cannot conduct a proper assessment and without having a bill that is reasonably complete
Yes.
and is capable of assessment. See Gwilym, please provide a copy
Yes.
urgently, electronically, unless you know what the stated basic costs are that you intend to charge. They may be less than the breakdown which was later provided. That's a matter for you. But you cannot conduct a sensible assessment on the basis of simply a bill that says, I am charging you £500. Now, why not?
Well,
Because why can you not, in the breakdown, say this £500 is, I was entitled to charge profit costs of £5,000, I was entitled to charge a success fee of £200, blah, blah, blah.
yes.
I decided only to charge 500 for these reasons, and then the judge can do what he would have done anyway.
Well, firstly, the breakdown is a breakdown of the statutory bill.
Right. Doesn't say that. It says must serve a breakdown of costs.
Breakdown defence bill costs.
But it says that. No, the rule says the solicitor must serve a breakdown of costs
Yeah.
for the cost to be assessed.
Yes. So the breakdown is not a breakdown of another bill or a bill that was delivered that's not part of the assessment. The breakdown is the breakdown of the bill that has been ordered
What
to be
was it
assessed.
in this bill, picking up my lord's point?
Yes.
What was it in this bill that didn't enable you to determine whether or not to have an assessment?
Well, if the bill is unclear, but if the bill is what we say it is, then it does enable us, because we can say, well, look, part of this bill is this £1,717, and that goes to the calculation of the success fee, so we can challenge those costs, and we can challenge the...
You did.
Yes.
And you got a breakdown which explained how those were all calculated, and you challenged it, and then at the end of the day, you lost.
No, you got £172 back.
Well, you got £172 according to the district judge, but according to the judge, the amount that the bill was asking for was no more than had already been paid, and what your client tried to get it down to left your client with nothing.
Well, Mr. Justice Lavender didn't say that the amount of... well, he did say that the amount of the bill is the amount of the demand for payment, but that simply doesn't make sense, because...
Can you, before you say why it doesn't make sense, could you just remind me, because I read all this last week, not this week, I've been doing something else this week.
Oh, yes.
And
As have I.
last week, I remember I read all Mr. Justice Lavender's 150 pages or whatever it is. What actually happened? You got 172 quid back from the district judge.
Yes.
What did Mr. Justice Lavender do in the end on the other substantive points not now appealed?
Yes, so the appeal... so essentially, Regional Cost Judge Bellamy, the district judge, in the paper review of the bill,
Yes.
he essentially held the solicitors to fixed costs per section 74.3.
Mm-hmm.
So they got £900, did they?
Yes, they would have got, so they only the amount of fixed costs that they recovered. On the oral review, the Regional Cost Judge changed his mind about that element, but he found, having regard to the informed consent provisions at 4693, that the fixed cost figure was the reasonable amount to apply anyway. So the solicitors still didn't get anything more. The result of that is
Anything more than...
anything more than the fixed costs recovered from
£900.
Yes.
What was the overall result?
So the result of that was that the success fee that had been charged was reduced to 15% of the 900 instead of 15% of the 1,717.
And that was 170 quid.
Yes. Mr. Justice Lavender, so that was appeal, and then at that stage, the Regional Cost Judge made his determination of what the amount of the bill was for the purposes of the 150. The appeal before Mr. Justice Lavender resulted in a reversal of the first element of that decision. So Mr. Justice Lavender essentially said that District Judge Bellamy was not entitled to find that £900 was the only thing recoverable, because he had essentially not taken into account what was reasonable. All he had done, and I hope I'm not doing a disservice to either judge, but all he had done was look at the informed consent provisions and determined that that meant that it should stay at the fixed cost figure.
And is that appealed?
So that was appealed, and Miss Justice Lavender reversed that.
So,
That's not appealed to this
No,
court?
no, that's
so
not.
you ended up
Yes.
with the same amount. You had got nothing back. It was all quits at that stage.
Yes. After Miss Justice Lavender's decision,
Yeah.
yes, that's reversed. That's
You
reversed.
accept that now. So the only appeal you're making is you say. Do you say then you succeeded, even though you got not a penny back, because the bill is £2,700?
I mean, your point is that the district judge was right to say the bill was £2,731.90.
Yes.
And Mr. Justice Lavender was wrong to say the bill was £1,571.50.
Yes, that's right.
And if Mrs. Justice Lavender was right, you got nothing. That's what it comes to. And it's a very, very short point.
It is, my lord, it is, and I fully accept that.
I mean, I understand all the other points you've made,
Yes,
but
of course.
that's what it comes to.
Indeed, and on this particular case, I accept it is a very short point. But it is the reason why we're before this court is that there is a wider point here, particularly in these sorts of cases.
Yeah, of course.
That if one is going to argue, as the solicitors did here, the amount of a bill is the £1,500 figure, which is not precise, but if I put it at that, and Mr. Justice Lavender is going to say, well, the amount of the bill is actually the amount of the sum demanded, and there's another potential argument that the amount of the bill is the amount that the solicitors actually had in terms of what they've received. The appellant would say, well, start at the very basic level and ask, what does the bill contain and what is required to be assessed? You have a breakdown of that bill, which is a breakdown of the £1,717 profit cost. And it has to be so that the court can assess the successful. So you break down the bill and you set out in full those charges. The court then assesses those charges. Both sides are put to the expense of objecting to the £1,717.
I mean, I think clarity is beginning to emerge. You say, unless you say in the bill what the costs are, profit costs are, it can't be assessed.
Yes.
And therefore, that must feed into 4610. It must feed into 7010.
Yes.
And I've won. But some people might say that's very strange since you lost.
Well,
because you've come away with £0.
Well, if I'm permitted, and my best laid plans of time estimates.
No, it's all right.
I do apologise.
You've been barracked.
The point about special circumstances, I can deal with quite shortly, and that is my lord's point. Even if we're right about the amount of
Right, you say even if you're right, that's what the special circumstances is for.
Yes, that's precisely what special circumstances is for. But there is, and I'm not going to get into those submissions because I'm about to make them, but there is another secondary point which is a very important one as well for the purposes of the client and for all the parties.
Mm.
And that is, and my lords will have seen this from my skeleton argument, but that is the point that because we say the true amount of the bill for the purposes of the assessment was £2,700, that is why the solicitors didn't object to that figure in the claim form at all, and didn't object to that figure explicitly being the amount of the bill to be assessed in the directions that my lord, the Chancellor.
Well, you say that, but you don't say they were stopped. You don't say it's raised judicata.
No.
You said it's just jolly unfair.
Well, it's not. It's more. I say it's more than that, my lord. I say it's more than that. I say that it is a reflection of the reality of this situation.
Yes,
Because
The judge disagreed with you on that point, didn't he?
well, yes.
So you've got to satisfy us that the judge was wrong to disagree with you, but just in colloquial terms.
Yes, I fully accept that, and I do say the judge was wrong on that point.
Because he says, well, as my lord just said, it's not res judicata, it's not estoppel. So what is it?
Well,
your point is the same point as you've just made to us,
Yeah,
and that is it needs to the amount of the bill needs to state the basic costs and how they're calculated. Otherwise, it can't be assessed, and so it's absolutely critical that it's in there, and that's why the solicitors accepted that was the amount of the bill.
yes,
There's one argument.
It is, but it doesn't. It doesn't. If one analyses what the solicitors did here, it doesn't actually make sense for them to turn around at the end of this case and say, "Oh well, when everybody's agreed that the bill at total to be assessed is 2,700, but actually for the purposes of the 1/5 rule, it's 1,500."
I get all that.
Now, what they could, sorry, my lord.
Why is it, let's say, that as a matter of statutory construction, section 7010 means what they say it means, and not what you say it means.
Yes.
If this court were to say a statutory bill must be clear, must state what the base costs they claim to have been entitled to charge, even if at the bottom it says we're only charging you 10p,
Yes.
so that the assessment can take place. Why is that not a workable situation?
It's not workable because it puts the client in a difficult position, and it doesn't put the solicitor.
Why does it put the
Why
client
is it
in
put
a
the client in a
difficult
difficult position?
Because the client will then have to assess a full bill, will have to agree that a full bill is going to be assessed,
Yeah,
and will have to work out which elements of the bill they may wish to assess.
yeah.
So one has to regard the basic costs as part of that bill.
Yes.
If one doesn't, and one only looks at the deductions, it will not be clear how those deductions are made up.
And you see,
No, but that wasn't my question. Is why does it put the client in a difficult position? If the position is the solicitor delivers a bill saying, I'm entitled to charge you this, I'm entitled to charge you that, that comes to 2,500, but I'm only claiming 1,500, which you've already paid. Why does it put the client in a difficult position?
My apologies, my lord. I misunderstood. In that circumstance, if it was that circumstance, then it potentially wouldn't. I mean, the case law has traditionally been that a solicitor shouldn't be permitted to do that, to put in a but say figure.
Well, that's not but say, because the trouble with but say is the way the Court of Appeal interprets it in the older cases is, if you pay me £78, I'll take it, but otherwise I'll take what I can get on taxation.
Yeah.
So the bill still remains £85.
But that's not this case.
But my example to you, which is what I think's happened here, is here's a breakdown of all our charges, 1,500 for this and 500 for that and blah, blah, blah. But all we are claiming is the 1,500, which has been paid. So we're not demanding anything else from you. Now that, as long as it's clear that's what you're saying.
Yes.
Because the only reason why there was any bill at all was because your clients asked for it.
But
Otherwise, as far as the solicitor was concerned, I mean, you can see from in the breakdown, rather striking, never mind what the statute may say, but the document,
yes.
page 119 in the call bundle, contains something headed in bold, cash account for client Mrs. Marta Karatysz. And it then says at the bottom, balance due to from client 000.
Yes,
It says it twice.
solicitors are obliged to deliver bills.
Yeah, well, but
Under
that's the
rules.
point.
I mean, the
So
fact that they don't.
What, going back to your point about
Yes.
the client in a difficult position, this client would have known from the bill that the solicitors had only charged £1,571.50 and they'd been paid it. And if that, for some reason, wasn't clear to her, from the breakdown of the costs, it would have been absolutely pellucidly clear that that was the solicitor's position.
Well,
Everything they wanted had been paid.
Well, there's a number of points in respect of that I wish to make. The first one is just the notion that a breakdown of costs can somehow remedy a prejudice
Well, I understand that point.
of a bill being unclear. But my Lord Nugee's example doesn't include the success fee point, and that is a critical issue, because what actually is happening here is not that the solicitor is saying 10,000, but we'll only charge you 1,000. What they're saying is 10,000, and we're using that 10,000 to calculate
Well,
this.
they can do what they like. I mean, the point is they've then got to justify that. In order to, when they get the breakdown, they've got to show that their calculations, which ended up with 1,000, was a legal entitlement.
They do, but as part the way they do that, and the mechanism by which they do that, is to have their statutory bill assessed, and their statutory bill that is assessed includes that element. That is.
I completely get the point.
My Lord, the Chancellor made the point about Mr. Justice Lavender, and of course I accept that I have to show that he was wrong to discount this agreement or this acceptance. But if one analyses the decision, as I say in my skeleton argument, Mr. Justice Lavender, with respect, doesn't turn his mind to the issue at all. He simply notes that it's not a res judicata point, which we accept. But then he says, I've taken it into account. But it's clearly crucial for the purposes, again, if one puts oneself in the position of the client, it's crucial, firstly, for all the reasons I've given, and I'm not going to repeat them. But secondly, if one accepts the reality, which I say the solicitors did in this case, if one accepts the reality that this is the bill to be assessed, how can it be right that at a later date, the solicitors can turn around and say, okay, we've all agreed that that is the amount of the bill to be assessed, but at this later date, for the purposes of the 1/5 rule, we're not going to accept it.
I think we can.
But it's not all bad news for the solicitor, I say, because what I say should have happened here is that they should have said, we accept the 2,700, we fully accept that, that is the amount of the bill, and the 1/5 rule has been beaten. However, we have special circumstances arguments, and on this case,
I see all
Yeah.
that.
Okay.
I mean, you know, I think Mr. Dunn, I think we now understand what your case really is, and we need to hear from Mr. Marwin.
Yeah.
yes,
Can I just, before you sit down,
yes, of course,
suppose you're right on all that.
yes.
Are there here such special circumstances as to disentitle your client to the costs of assessment? And
Well, I'm
if
very
not, what-
grateful, because having said I was going to deal with that briefly, I omitted to deal with that, so I'm very grateful to my Lord for that. There are practical issues with raising special circumstances on a second appeal, I would submit. So if special circumstances are going to be argued, and I hope this isn't a rehash of previous arguments from this week, but I would submit that that is a matter for the assessing judge to consider at the end of an assessment.
So if you don't raise it at that point, you can't raise an appeal. So-
You should. Well, ordinarily you should. I have some sympathy for the solicitor's perspective. I see my learned friend laughs wryly, but I have some sympathy for the solicitor's perspective, because at the point of the first instance decision, it's right to say that we had won, and so it wasn't a question of.
Yes.
So that is a fair
It
point.
can't be right that you can only raise it at first instance if it's not relevant.
Yes,
Only
I think
becomes relevant on appeal.
that has to be a fair
Then
point.
that has to be. I mean, there's an issue as to who needs to
Who needs to raise
assess
it?
what the special circumstances are.
Yes.
But
Yes, indeed.
that's really your point, isn't it?
Yes, that's the first point, that it's a matter of discretion for the judge who has heard the assessment, and because it is considering all circumstances, it is the assessing judge that should.
But where in the appellate court, here, Mr. Justice Lavender, reverses a
Yes.
decision, substantive decision of the first instance judge, it's absolutely standard for the appellate court to substitute its own discretion as to
Yes.
costs.
It
So
certainly
why could Mr. Justice Lavender not have decided to disallow the costs on the grounds of special circumstances?
Well, and this is where it won't surprise anyone, but this is where my sympathy for the solicitor runs dry, because before Mr. Justice Lavender, the solicitor could very easily have said, in respect of this element, they could have said, this is our appeal. Our appeal is that the 1/5 rule, it was the wrong, District Judge Bellamy used the wrong figure. But if that's not right, then special circumstances apply, and that could have been dealt with at the first appeal. It wasn't mentioned at the first appeal at all.
No, but again, the solicitors won on appeal, so we didn't need the special circumstances argument. If we now accept your argument and reverse his decision on the 1/5 rule, why can't they say, but we want this court to exercise a discretion as to whether there are special circumstances.
Well, they're in exactly the same position in this second appeal as they were in the first.
It's a classic respondent's notice point in this court. They say, in effect, Mr. Justice Lavender was the result he reached in his order is correct, for reasons other than the ones he gave in his judgment. And one of those reasons is special circumstances. In other words, if you, the appellants, are right about everything else, then there are special circumstances. That's what
yes.
Mr. Marvin says in paragraph 3 of his respondent's notice.
My learned friend does, but...
Let's assume it's open to him to argue.
Yes, of course. I mean, I would simply just say that...
What do you say about it?
I don't want to row back, but I would just simply say that if it is open for the solicitor to argue in the second appeal, it was perfectly open for them to make the same point.
I understand. I understand that.
But I say that the special circumstances here is a very different species when one is looking at a second appeal and the costs that flow. And what I would submit is that one needs to look closely at what is being asked for. If it is a question of the costs of the assessment, the first instance costs of the assessment, then I would accept that special circumstances can have an impact on whether the costs before District Judge Bellamy should go to the client or to the solicitor. But now the first appeal is somewhat different because half of the first appeal at least was to do with the matters that we lost and we haven't tried to appeal. So the costs there are not going to be disturbed. It's only the costs in respect of the amount of the bill decision that are up for discussion anyway. And the point there, which can be repeated for the purposes of this court, is that the solicitor at any time could have said, we accept the bill is what we all agreed it was for the purposes of the assessment, but so we accept that the bill is at 2,700 for the purposes of the assessment, as we have said it is all the way through, but we say for the purposes of the special circumstances we should have our costs of the assessment. Now
and if they didn't say that, then they have to
in this appeal
follow the event.
Indeed, and in this appeal would never have got off the ground.
Well, you can come back on special circumstances.
Yeah.
I'm great. I appreciate I'm taking up too much time.
Okay, thank you, Mr. Dunn. Mr. Marvin.
My Lord, yes. Just to start with the obvious point, for the avoidance of doubt, at the end of this exercise, the claimant got absolutely nothing back. Just to be absolutely clear about this, the district judge gave the claimant a refund of about £177 from the damages deduction. Mr. Justice Lavender ordered the claimant to pay that back. So, my Lord, the Chancellor is absolutely right that the claimant is in exactly the same position financially as if she had never launched this challenge in the first place.
And that's not challenged on appeal to this court?
No, and we've been through a paper hearing and an oral hearing before the district judge on appeal, so a second hearing and a third round of submissions. And after all that, the claimant has benefited absolutely nothing from these proceedings. And indeed, if I may say, it's even more stark than that, because we know that the claimant is on a CFA, and as matters stand, she doesn't owe her solicitors any money because she's lost. She hasn't got anything back. It will only be the allowing of this appeal and the making of a costs order in the claimant's favour that will trigger her liability under the CFA to her solicitors. Otherwise, she owes them nothing. So this is all about solicitors' costs. And there's an important policy point behind this. And my Lord Nugee, if I may respectfully say so, has it absolutely right. The statute bill at page 203, there are lots of things the client can do if they're unhappy with their solicitor. Indeed, one of them is mentioned on the back of the statute bill, which is at page 204, which is if you're unhappy, you can use the internal complaints procedure. Of course, this client never did that. She came in touch with Check My Legal Fees 2 years after the event. There's an ombudsman, there's a regulator. But the Solicitors Act assessment procedure is all about the money. That's what it's about. And when it's said, well, we didn't know, the client didn't understand this bill, etc., etc., it is all, respectfully rather synthetic. When Check My Legal Fees and the claimant launched these proceedings, they thought they had an overarching point, so that it didn't matter whether the district judge touched the figures. They thought they had an overarching point, that we weren't allowed to charge anything above inter partes recovery because the client hadn't given informed consent, etc., to do that, and therefore we had to pay it all back, and it didn't matter whether the judge thought that the hours worked and the rate charged was reasonable or not. But they've lost on that point. But that's really what it was all about.
And what Mr. Justice Lavender found, in terms in his judgment, was that they knew that in fact all you'd ever charge was the 1571.50.
Yes.
So they were in absolutely no doubt whatsoever.
And by the time they launched, I mean, two things. Firstly, by the time they launched the assessment proceedings, the claimant had the benefit of Check My Legal Fees advice. So if there was any difficulty understanding the document of 203, she had professional help. But secondly, one thing they undoubtedly didn't know was what shape the argument about section 70 subsection 9 would take, because that only emerged after they launched these proceedings. So they weren't proceeding on any assumption about what we will say about 79 or the amount of the bill. And indeed, I suspect they knew very well what we were going to say about it. But what's at the core of this appeal is whether this court should encourage or discourage Solicitors Act assessments where the client gets absolutely nothing back. If the client has actually been overcharged, to use that term in any realistic sense, then fair enough. But if the client actually isn't owed any money, should the court encourage or discourage a Solicitors Act assessment essentially as a I would say, pointless exercise with huge amounts of lawyers' costs on both sides? And if my learned friend is right, then the court encourages that. And if I'm right, then the court discourages that. And I can illustrate that nicely by just running through a few figures on the bill on page 203. My learned friend took some hypothetical figures, but I'll take some actual figures that the district judge gave, which weren't taken any further because these were matters of assessment and discretion and reasonableness. He actually did reduce the 1717 figure. He said, I'm only going to give you 9 hours at £120 an hour. So he took that down to 1080. And he reduced the success fee. He said you can't justify 100% success fee. You could only justify 15%. And in fact, that didn't hit the cap. So that came down to 162. But then if you add all the VAT on and you add the disbursements, you don't touch the 455.50 at the bottom. Now, in fact, the district judge, that was all before the district judge academic, because the district judge went on to say, because there wasn't informed consent, you're limited to inter partes costs. That's the 750 figure. But as an alternative, although academic because of his overarching decision, but that was the one that was overturned. And that's really what's at the core of this. If the client isn't going to get any money back, was an assessment a productive exercise? And I say the answer is obviously not.
Do you have, I'm sorry to be troublesome, Mr. Marvin, do you have a figure for what the district judge said on his reassessment? That's to say the 1080 plus the 160.
I can just count.
Plus the VAT, yes, plus the disbursements.
Let me do that very quickly.
My lord, I don't want to interrupt, but it's not the disbursements, it's only the ATE, because the disbursements are paid by Aviva, so they don't form
part. Oh, okay. Yeah, it's the VAT. Yeah.
It's just the ATE.
Yeah, it's the VAT. And the ATE, please.
Yes.
The 1080 plus VAT comes to 1296, I think.
Yeah.
Yes, I think the total will come to about 1894.
Yeah. So on any view, the 1571, which the solicitors received,
was reasonable.
Was less.
Yes. Yes, exactly. And in fact, just I think your lordship has this point. The district judge actually reduced the cost figure to 750, not 1080.
But he reduced it for a different reason. That's not before.
A different reason, yes. And that was precisely the point that Mr. Justice Lavender overturned.
That's the point that's been overruled on appeal. Yes. It's not appeal to this court.
So that's what's at the core of this appeal. If you can tinker, sorry, that's probably a slightly pejorative way of putting it. If you can get an adjustment to some of the figures the solicitor used, but you don't get any reduction from what the solicitor was asking to be paid, is that a reduction to the bill?
That's the core of your respondent's notice.
Yes.
But the core of the appeal is what does a proper statutory bill look like, and how much is it for for the purposes of section 7010.
Yes.
Now, that point, after a lot of debate with the court, Mr. Dunn has made a single point. He says you can't assess a bill that simply says, I want £1,000 for this work, where it does not say what the base costs and success fee are that are charged. And even if, therefore, you're going to say, I will accept £50, you cannot have a bill that is a proper bill that needs to be assessed unless those figures are stated, and therefore, section 7010 must be construed as meaning that when you say the amount of the bill, it's the amount of those costs. Now, that's what he says, and he's right, isn't he, that the bill has to state the profit costs and success fee you want to charge, and even if it then says only 50 quid is payable, it still has to do so. And your point is the simple one, which is that yes, it has to state the base costs and success fee, but for the purposes of section 7010 and 7010 only, amount of the bill means what you're asking to be paid.
Yes, for the purpose of 79, the amount of the bill is you're asking to be paid. So I'm so sorry, I didn't mean to quibble. I ought to be clear that that this has come in, that the suggestion that this court has to look at what a statute bill requires isn't really raised in the grounds of appeal, and I express some concern about that because there is authority on essentially what is the bare minimum you have to put in a statute bill.
What is the authority?
The leading case is a case called Gwilym.
That's the one you mentioned.
That's the one. And essentially it comes down to you've got to tell the client enough based on what's in the bill and the other information the client has that the client knows what they're being charged for.
So, my lords, I'm sorry to interject, but the Gwilym case is in fact in the Belsner bundles that assists, and I can take you to, just give you the reference to the relevant passage.
Which page?
So it's page 1346 in the authorities bundle.
Thank you. It's Ralph Hume Gary versus Gwilym 2003 One Weekly Law Report. Right, thank you.
And
It's paragraph 70. Isn't
paragraph 70 is probably it summarises the principles.
Thank you.
I mean, it doesn't arise. Can I just say it can't arise in this case because if the claimant had said that the document at page 203 wasn't a proper statutory bill, forgive me, they couldn't have sought an assessment of it. Because it's only a bill which you can seek to have an assessment of. So what they should have done if they were saying that isn't a proper bill is demand a proper bill. Once you seek an assessment of a document, you are accepting that it's a bill because it's only a bill that the court has jurisdiction to assess under section 70.
I don't think it's disputed that this is a statutory bill. I think that the point that's taken against you is this bill, as it had to, split out the basic charges and the success fee, and it's those things which are assessed. So that's the total of the bill for section 70 purposes.
As a high watermark, I would submit that wouldn't have been necessary. It would have been, and this may not have been good practice, but it would have been acceptable simply to say, we are charging you an amount of 116 plus 455 in respect of your claim. It wouldn't have been necessary to provide the further detail. But the important, and I say that's the Gwilym point, just how much is the client, are you required to put in a bill so the client knows what it is in respect of which they're being asked to pay. But the important point in my submission for this court today is whatever level of detail a statute bill requires, and whatever level of detail it has, the amount of the bill is the amount for which it demands payment. My submission is really as simple as that. And indeed, whatever the bare minimum...
But it's not this bill's then naught.
Well, no, when I say the amount for which it requires payment, that goes backwards as well as forwards.
But it is that formulation is really unhelpful.
Oh, I'm sorry, let me try and better formulation.
Let me formulate it and you tell me if you agree.
That will be much better, my lord.
My view about what it could be said to mean is not what sum is demanded by the bill, nor what is the totality of the bill which the court is required to assess, which is what they say in their skeleton, but what is the total sum that the the bill is demanding be paid to the solicitors, whether or not all or part of that total sum has actually been paid.
My lord, that's much better than I did, and I respectfully adopt that. That's and whatever details required, it's the bottom line. It's the bottom line.
And that is right under Section 79, sub 9, because the purpose of Section 70, sub 9 is to decide who's won.
Yes.
Yeah.
And did the client get more than 20% of what they had to pay?
And truthfully, none of that matters. Therefore, although he's maybe absolutely right, by the way, Gwilym talks about contentious costs, so this may be nothing to do with anything. But the point is that he may be absolutely right that in a case of this kind, a bill has to show base costs and success fee. Otherwise, the client can't know. And it could be argued in another case, which hasn't been brought here, that it's not a proper bill unless it does. Not a statutory bill unless it does. But none of that affects the proper meaning of Section 79.
My lord, indeed.
And in any event, we know that the process of assessment will require a breakdown, and the breakdown will give those figures. So whether it needs to be in the original bill or not, by the time you come to the process of assessment, we know it will split out the base costs and the success fee and all the other elements which are to be assessed, because we know that what the cost judge is going to do is go through it item by item and identify whether sums are reasonable or not.
But that may not be good enough, because as Mr. Dunn says, the client has to know at the point of the bill whether it is to be challenged, and unless he knows, at least in bare outline, what the charges are that have been reduced, it's no good knowing them at the breakdown stage, because that's after the assessment is being undertaken.
Yes.
You do need to know the basic principle of how the charges are reached. But again, that all comes down to what needs to be in a statutory bill. It doesn't come down to the proper meanings under the statutory construction of Section 79.
My lord, yes. And just on that, your lordship, perhaps I might posit it in a slightly less absolute way. Of course, it's highly undesirable that the client only knows at the stage of the breakdown, but there are cases that say, essentially, if the client drops the assessment at that point, they might expect to get their costs back if the solicitor's been less than forthcoming with information.
Yes, but if you look at Gwilym does say what the client needs to know is sufficient knowledge to take advice as to whether or not to apply for the bill to be taxed.
Yes.
And if you just get £1,200 full stop, then you might not have sufficient information. It varies from case to case.
It varies.
You might not have sufficient information to know whether to take any advice at all, because you don't know how much of that is success fee and how much is base costs. You don't know how the solicitor proposes to justify them. You don't actually know what you're being charged for. So the Master Rolls may very well be right that the sort of detail in this bill is actually needed, but it doesn't matter for our purposes, because we've got the detail in this bill which tells us what the base costs are, what the success fee is, what the disbursements are, and what the bottom line is. And the question is, do you look at the bottom line or do you look at the constituent elements?
And if I can just make a more general point, forgetting for a moment about a success fee case, the court will surely want to encourage more, not less, information in a bill. So let's suppose you have a solicitor with £10,000 on the clock, and they only want to charge. So they look at it, they think, well, we can justify this, but we don't want to charge the client that much. It's got a bit out of hand. They only want to charge 7. So it's just base cost. I would suggest that if the solicitor simply says in the bill, base cost £7,000, no one could dispute that that was a bill for £7,000. Then the breakdown comes in and it's 10,000, and the client has to get and maybe as a surprise to the client has to get £3,000 off the breakdown before they get the penny off the bill. Much better that the solicitor says in the bill, I could charge you £10,000, but I'm only going to charge you 7. But the way my learned friend submission works is that if the solicitor does that, he's going to say, well, this is a bill for £10,000. We go to an assessment, the breakdown's reduced to 8. His client doesn't get a penny, and he says, well, we've got 20% off the bill. So it has the approach of saying that the bill is that not the amount for which payment is required, but a higher amount that perhaps the solicitor might have paid, will have perverse consequences. That actually it will discourage the solicitor from being transparent in the bill that they're giving the client a discount. And firstly, transparency is a good thing, and secondly, discounts are a good thing. And this court, I'm sure, wouldn't want to deter either of those.
I mean, the real point is that this was a rough and ready provision, which I believe was introduced in 1834. And in 1834, they didn't have all this sophistication, and they didn't charge success fees because they were illegal. And therefore, the question as to what it means at least has to be looked at in the background, that this has been in legislation for years. And what it's about, as you've submitted very eloquently with your 10,000 and 7,000 example, is did you get a reduction on what I was being asked to pay?
Yes. So my lord, unless
So if the solicitors in this case, I mean, the checkmylegalfees.com knew that the amount of money you'd asked for was 1571.50. They knew that because you've been asked to produce a statutory bill, you'd done what the Act requires and what Gwilym requires. You said that the base cost of 1717. This is how the success fee is calculated. Total of that is whatever it is, 2,700 odd. But in fact, we're only charging 1571. Now, if they'd gone to an assessment, and as a result of the assessment, the district judge had said, well, the total amount after all the calculations to which they're entitled is £1,300.
yes,
Then they'd be laughing,
Yes.
as it were, metaphorically.
yes,
And the reason why they're not laughing is because the total that he came to was 1870
yes.
and not 30.
My lord, that's absolutely right. If I'm not
There's
mistaken.
nothing wrong with this bill. I mean, it could have been expressed more clearly in terms of how much had been taken already and why. But in terms of, did it tell the client how you calculate the figures?
Yes, I mean,
It does, doesn't it?
I mean, obviously, I'm sure this court will be given valuable guidance to the profession on what bills ideally ought to look like. I mean, all I will say is that this was 4 years ago, and this point about Section 70, subsection 9, perhaps wasn't seen coming. I mean, what this bill doesn't do is to total the two figures at the bottom, the inter partes figure and the damages deduction figure, to give the amount of the bill. But of course, that's really only. I mean, if the court were to say, well, it would have been better if the bill had done that, of course, respectfully, one would readily understand that. But of course, it's really only important because we're now arguing about Section 70, subsection 9. What this bill, I would respectfully suggest, does do is tell the client the bottom line. It tells the client, this is what we've got back from the other side. And I pause to say that's notionally paid by the client, although not in a real sense. And this is the extra amount that we have taken from your damages, limited in the way described and already paid.
So, would it be right to say that properly drawn bills ought to state the agreed charges or the amounts that the solicitor is intending by the bill to charge, together with the disbursements, making clear what is base cost and what is success fee in a case of this kind, and then say what sums have been paid by whom, when, and in what way, because that's important, what sum the solicitor claims to be outstanding, because that's important, and what sum the solicitor is demanding that somebody else pay and who.
Well, my lord, I can answer that in two parts. I wouldn't concede that a bill to qualify as a bill had to do all that, but it's, if your lordships are saying, would that be sensible guidance to
a good bill.
give, I can't think of any reason why I would want to disagree with that as being sensible, best practice guidance.
Plus VAT.
Plus VAT, of course, yes.
I would never forget.
My lord, I just
Can I ask you a question? Is this a VAT bill for the VAT legislation?
I don't know the answer to that. I mean,
Because if it were, you'd have to pay HMRC
and
the amount of VAT on the bill, which is more than the amount of VAT which you ultimately end up being payable for. It seems
because this is 2 years after the event, I suspect the answer is. I mean, the solicitor, and I'm not the.
You're not a VAT expert.
No, I'm not a VAT expert. No, but obviously the inter partes payment of the damages deduction had been received 2 years before this bill was produced. So I assume that whatever was done with VAT, and I'm not qualified to say what I don't know what was done, and I'm not qualified to say what should have been done, but whatever those were,
They
were or
already
weren't
paid
done.
back 2 years
They would have
previously.
paid that already. Yes. So there would have been a tax point rather earlier. This is not the tax point.
No, because it's all paid. I think it's fair to say these days, most solicitors, I perhaps overreaching there, it may be that these days, because solicitors are aware that these challenges are coming down the line, and frankly because there are time limits under the Act, it may be these days solicitors are more inclined to produce this document at the end of the retainer, whether it's asked for or not. In which case there may be a different answer to your Lordship's question. My Lords, I just wanted to say something about special circumstances, not so much about the substance, because the substance is self-evident, even if I'm wrong. And of course this only arises if Mr. Justice Lavender is wrong about the amount of the bill. Even if Mr. Justice Lavender is wrong about the amount of the bill and it's a higher amount, the argument for special circumstances, if it's open to me, is an obvious one. This is all about the money. The client's got nothing back. It's all been a waste of money. That is the most obvious special circumstances for saying not merely the client shouldn't get her costs, but she should pay the solicitor's costs. I want to say a bit more about whether it's too late to run it. And the short point is the one that in a slightly different context my Lord Nugee raised, that when courts make an adjustment on appeal, they inevitably revisit the costs below, and you're not required to have already made arguments in the courts below that simply couldn't have arisen on the basis of those courts' decisions. So before the district judge, the special circumstances argument wasn't open because the claimants really had, and it's telling we're all using this word, the claimant really had won before the district judge. She'd got a refund from the damages deduction. So one couldn't have said, well, the claimant, this is all a complete waste of time. So that argument wasn't there. Before Mr. Justice Lavender, the argument didn't need to be deployed because Mr. Justice Lavender said the amount of the bill is what I'm arguing, the lower figure, and therefore on Mr. Justice Lavender's analysis, the claimant had not got one single penny off her bill. So I didn't need to raise special circumstances to say we should have our costs. It's only if, and the reinstatement of the damages deduction isn't a subject for appeal. So that's now a given. But it would only have been if Mr. Justice Lavender had said the claimant's got to repay the money, but had then gone on to say, but technically she's got a 20% reduction off because the amount of the bill is the higher amount. At that point, one could have, and I can say with some certainty I would have, said, well, but this is, in the real world, this has been a waste of time, there are special circumstances. But we never reached that point before Mr. Justice Lavender, and we will only reach it before this court if this court allows the appeal from his decision. But the point has never been there to be taken before, and that's all part and parcel of if the court were to disturb the judge's decision on the amount of the bill, the court would simply revisit the cost consequences of that essentially afresh. And that's, I make the point now because it's an obvious point to preempt, but really the point at which special circumstances would arise is in the event that this court gives judgment allowing the appeal. But obviously I know the court won't want us back on that, so, and it's an obvious point to make, so I make it now. Mm-hmm. My Lord, may I just turn my back for a moment? My Lords, unless I can assist further, those are my suggestions.
Thank you very much, Mr. Marlin. Now, Mr. MacDonald, first of all, start by persuading us that you really have something that you need to tell us.
Well, hopefully I have useful things to say just on clarifying a little point about Gwilym and then on the statutes as well. So I'm really just mainly trying to assist the court rather than address any specific issues, save for one point that I want to correct.
Well, what do you correct the point? So here's the correcting point.
The correction, it's very simple, is that my learned friend Mr. Dunn said the purpose of this appeal was for Miss Karatysz. And it's quite clear that the only people with any interest in this appeal, I checked my legal.
Well, we get that. That's
we know that.
contentious
We know all
point.
that.
We know that because we heard that last week.
That's the
That's
jury
earlier in the week.
That's the jury point.
That was the correction.
Okay,
That's right.
what's the other points? Because I don't really think you have locus to argue the law on this case.
I understood. So it's just in respect of Gwilym. Your Lordship, the Master of Rolls, asked, this is about contentious business, is it applicable? There are specific rules about contentious business and bills, and that's section 64 of the Solicitors Act. So that's just to draw that to your attention.
So does paragraph 70 of Gwilym apply to non-contentious bills?
I would have to investigate that further. I expect
We'll ask Mr. Dunn.
I expect it does, but these I'm sure those either side of me will have a view. But it is specifically in the context of a gross sum bill, which is something for contentious business under section 64. And the other point on Gwilym is just to identify that one of the relevant factors is the sufficiency of the knowledge of the client, which will vary from case to case, and that's in the same paragraph. And so that brings in the points Mr. Marvin was making about the fact that check my legal fees were already instructed. But I won't go any further. I just flag that the circumstances and the knowledge are also relevant factors.
Okay.
So unless I can see further.
No, thank you very much.
Yeah.
Right, Mr. Dunn.
Well, there's a few points. The first point is that gross sum bills are only, as I understand it, are only permissible in contentious business. So, Gwilym and section 64, obviously my hope is that these aren't non-contentious costs, but if they are, then a gross sum bill is not permissible in any event, which may be an unintended consequence. These are non-contentious costs.
But does Gwilym, are you saying therefore that Gwilym gives this court no guidance?
Gwilym gives guidance in generality, but it doesn't give guidance in respect of gross. If it's where its discussion is of gross sum bills, it only gives guidance if.
Well, is it a gross sum bill?
About bills now.
Okay.
But if we're wrong in Belfast, then
Okay, let's assume for just a moment that you might be wrong in Belston. If it's a gross sum bill,
yes.
Is the bill in this case a gross sum bill if it is a non-contentious bill?
It doesn't set out that is one of the consequences of a finding that they're non-contentious costs, because a gross sum bill is one that doesn't set out individual items. I would have to.
Is this a gross sum bill?
Yes, I would say it is a gross sum bill.
So it's illegal.
Doesn't have any detail at all.
So it's illegal.
It's not permissible under the statute if these
So
are
it's not a
non-contentious
valid
costs.
statutory bill.
Well, not if these are non-contentious costs.
Nobody took the point,
No, it's never been
Well,
taken.
and it went to assessment before the district judge.
Well, in fairness, and I hesitate to use the B word in case my learned friend Mr. MacDonald rises, but in fairness, the whole non-contentious contentious issue in Bells only arose really at the first hearing. And that's the point of my overly long note that my Lord the Master of the Rolls received and the bench
Well,
received.
it may have done, but it's been the elephant in the room for all these cases. And it's an elephant which is now going to be...
Yes.
Shot.
My Lord says shot. I think
Can't shoot elephants.
you can, but I think it would be a messy business. I hope it'll be less messy than that. But the point is, it had to be resolved. So it's going to be resolved. Now,
Yes.
if it's I mean, where does it say you can't have a gross sum bill in non-contentious business?
The Solicitors Act at section 64,
64.
yes, provides. So section 64 in the heading non-contentious.
We've got
Form of bill of costs for non-contentious contentious business. I'll just check that we do have it. So it's at page.
I thought 64.1 says it could be a...
Yes, for contentious work.
No, where it's not... Oh, I see.
Yes.
Contentious work, yes.
Well, where does it say it's illegal to have a gross sum bill in non-contentious business?
Because as in non-contentious business, which is dealt with paragraph section 56 of the Act, which if your lordships have the white book is on page 227 of volume 2.
Give us a section again. So the page again,
section 2, my lord. Sorry, volume 2, page 227.
56 which? I thought this was 56 was about a committee.
No, volume 2 of the White Book Solicitors Act 1974.
What page of volume 2?
2278.
2278.
Yeah, but which section are you looking at?
Part 3, section 56.
56 what? 4?
So that is essentially where the Act sets out how costs can be dealt with under non-contentious
No, it
business.
doesn't. It sets out how you can make an order as to remuneration for non-contentious business.
Yes,
And it says,
and that's the
under sub 4,
2009 order.
the principles prescribed by an order may provide that solicitors should be remunerated by a gross sum.
How about 57.2? Oh.
Yes.
Now you make general orders.
Well, my lord, Lord Nugee, that is a good point.
That's a non-contentious
That's
business
non-contentious
agreement.
business.
Yeah, right.
Yes, that is the way. I mean, a remuneration order of 2009, which sets out the remuneration in non-contentious matters, but to have a gross sum agreement requires a matter to be a non-contentious business agreement.
Well, hang on a moment.
Well, where does it
The
say?
principle, subsection 4 says that an order under this section may provide that the solicitor should be remunerated by a gross sum.
Yes.
Got nothing to do with a non-contentious business agreement. That's what the order can provide. Does the order so provide, or does it say you can't do that?
Well, that would be the remuneration order of 2009,
Yeah.
Yeah.
which is in the Belsner bundle, but I don't think is in this bundle, unfortunately.
Okay, well, we've got the bells in the bundle. And if you look at the remuneration order, which is at tab 24.
I'm afraid I don't have.
Okay, well, it's pretty simple. It says all sorts of stuff, and then it says solicitors' costs must be fair and reasonable, having regard to all the circumstances of the case. It doesn't say anything about gross sum bills.
No. So the order.
Why does, I mean, it's one thing to say the order can provide for gross sum bills.
Yes.
That doesn't mean that if it doesn't, gross sum bills are illegal.
Well, the settled understanding, and this is reflected in Friston on costs.
Right, what does Friston say?
Well, Friston on costs, for example, at page. Does my lord have Friston on costs?
No.
No.
I mean, we've got bits of it.
Yes, of course.
Anyway, which page?
So page 66,
Mm-hmm.
which is entitled "The Language of Costs," under gross sum bill.
Mm-hmm.
It says a statute bill that lacks detailed items used only in relation to contentious business. And then
Well, that just may be a practice.
well, the only way a bill of costs contains detailed items unless under the Act there is an ability to send a bill which doesn't contain detailed items. And the reason for that is obvious, because a client is normally entitled to a detailed account of the makeup of the bill.
It's never going to get what's in the breakdown.
Well, they often do, which is why breakdowns are not always required in solicitors. I mean, often if a statutory bill is requested, the cost lawyer may draft the bill, which is considered to be a detailed breakdown.
I mean, how can we decide this anyway? We have to assume, don't we, what was assumed by the courts below, namely that this was a statutory bill capable of assessment.
Because nobody's ever taken the point.
Well, it is.
It wasn't said by your client at the time when the statutory bill was received. Well, that's not good enough. I want more.
No, this is a point I want to
And that's
come
just
to, my lord. Yes.
So that's right, isn't it? So this is just a non-point.
Well, it's right that we said that, but the point is, from my perspective as counsel for Ms. Karatysz, let alone counsel for anyone else, our stance has always been that these are contentious costs. So
we understand that.
I don't put that
That's not
forward.
before the court in this appeal.
But in this appeal, if this court is going to decide that MOJ portal costs are non-contentious costs, if they do decide that, which they may or may not. Who knows? If they do decide that, then that does have an impact on bills in MOJ portal cases, because, and if your lordships and I can anticipate that this probably wouldn't be welcome, but if your lordships would want short submissions on this point, but it is clear in my submission that
I thought we got very long submissions yesterday.
Well, if it has implications for how bills are drawn, then it has implications for how bills are drawn. I mean, we can't legislate for what may or may not happen. We're certainly not going to be giving some sort of guidance about it.
No.
There's relevant firms who do this sort of business on this basis, to the extent people still do. We'll just have to live with it and work out what the answer is.
Yeah, no, of course. And
Or ask my lord to issue another order under the section 56 of the Solicitors Act.
Yes.
Not impossible.
Not that isn't.
Which is certainly something which I think we may even have mentioned.
Yes, that has been mentioned, and of course that is an option for the court.
I can't speak for my lord, but one would envisage there be some sort of consultation process, during the course of which solicitors who did this sort of work might say, well, you need to cover bills which are gross sum bills.
Yeah, I think you should address the points Mr. Marvin made. Really.
Yeah.
So, one of the points my Lord Nugee raised was the point about VAT, and VAT is mentioned in our skeleton argument specifically.
Where
it is an important. So it's at page.
In which skeleton?
It's in the core bundle skeleton for this appeal.
Whose skeleton? Yours.
And
Which
it's
paragraph?
page 33 of the.
Yeah, which paragraph?
Paragraph 99.
Yeah.
And it's also.
You say it was a VAT invoice.
And it's also raised at page 18 of the same bundle, again, our skeleton argument.
I don't have bundles. Can you give me the
Oh,
paragraph of your
Yes, of
skeleton?
course. It's the footnotes on page 18,
Yeah, which?
and it's paragraph 10. It's footnote 3.
But this is all, the point in paragraph 99,
Yeah.
I expect, is a completely different point. It's not a VAT point as such.
What?
It's simply the point. It's seeking to distinguish the decision of Mr. Justice North by saying, well, unlike in that case, where the judge found that the earlier document was the bill, the one that demanded whatever the figure was, I forget now. There was no earlier bill. This is the only bill. That's the point that's being made.
Well, the point
And the
is...
breakdown came later.
Yes, but the point being made is that this bill has a VAT number on it. It's listed on it. At the bottom of that table, it's dated for the purpose of the bill. This is page 203 of the supplemental bundle.
But why does this rebut Mr. Marwin's argument?
Well, it lends, because the VAT is said to be 431.48.
Mm-hmm.
If this is a VAT invoice, then that means that VAT would need to be accounted for.
Mm-hmm.
That lends weight to the appellant's argument that the total, in reality, is the total on the signed line.
But we just don't know because we don't know what the position was between SGI Legal and the customs. They may or may not have accounted for 43148. They may have chosen to account for that figure. They may have agreed a lower figure.
But that's
because this is all 2 years after the event, as Mr. Marvin pointed out.
Well, yes, it is.
They'd have had to account for the VAT on whatever the fees were long before this document was produced. Otherwise, they'd have had penalties.
Well, it's long after the event because the solicitors didn't do what they're obliged to do and send a bill. So yes, it is long after the event. But this goes to 2 points. This goes to clarity and it goes to what the actual total of the bill is.
Well, I mean, if you're right, it's a VAT invoice. It does support your proposition that this is a bill for the amount of the VAT invoice. Yes. I agree with that.
Well, it is a bill.
But it may not be conclusive, but it certainly supports it.
It's a formal dated invoice which has a VAT number on it. Now this has not come out of the blue from my Lord's pertinent question. This has been foreshadowed, but there's no answer from the solicitor as to what it is. But that's an important point.
Well, the answer is that they received the money 2 years before, and if they haven't accounted for VAT, they'd be in breach of the legislation.
But I would put it this way, my Lord, that if one is looking, if a consumer, if a lay client is looking at a bill which has a total with a VAT,
looks like a VAT invoice.
VAT total that looks like a VAT invoice, does that not, I would suggest, support the view that in reality that is what this bill is made up?
All right.
Yeah. So if it looks like an elephant, it is an elephant, even if it's
well,
a giraffe.
prone to being shot.
If it looks like an elephant,
yes.
If it looks like an elephant, then a client is entitled to say that it is an elephant.
Yeah, I get that.
Yeah. Okay.
The argument about, well, the client had professional help by the time the statutory bill was delivered is in my respect for submission, a bad point, because one can't give guidance and decide these cases on the basis that a client might happen to have gone to a particular firm of solicitors who have specialism in this. The point my learned friend made about questioning the status of the bill is absolutely right in this sense. We don't question the status of the bill if the bill is for the amount we say it is. Because if it is for the 2,700, then we don't question the status of the bill, leaving aside the gross sum bill point. Because that is what the bill says it is. If it's for a bill on the contrary, which my learned friend says, if it's for a bill for a figure which is not listed at all on there, then that's a different matter. But of course, our entire point is, this is not a non-compliant bill, this is a compliant bill for 2,700. And really, the answer to my learned friend's point is, I say this, that there is a reality here about the situation that occurs in these low-value cases. And the reality is that there's an element here within these bills that is discounted, but there's also an element, the same element, which has to be kept at that figure for the purposes of a success fee calculation. And there is an inherent conflict in that respect. Because if this bill discounted and then set the success fee on the discounted amount, then there wouldn't be a problem. But it doesn't do that. It says, here's our figure, we'll calculate the success fee on that figure, and then we'll discount that figure. So there's a line going down to that discount from the profit cost or the basic cost figure. But the success fee does not get calculated on the discounted figure.
That argument is dependent upon saying that the success fee can only be charged not on the recoverable base costs, but on the charged base costs. It's the same argument as we had yesterday in Belson. If the recoverable base costs were 1717, which is what Mr. Justice Lavender found,
Yes.
then the success fee was right, because it was a recoverable. It was 25% of the 15% of the base costs.
Yes.
Recoverable.
Yes. But this is therein lies the problem, my lord, in my submission, because what the solicitors are saying is the 1717 is absolutely crucial for determining one element of this bill, the success fee, but is not crucial in terms of actually what we're asking you to pay.
Yeah, but that's because the issue for the court is what is the amount of the bill?
Yes.
Under section 70, subsection 9. Now, in order to get to the amount of the bill, you may have all sorts of figures that are set out in order to arrive at a series of complicated calculations.
But in order for the solicitors to be right about this, then the amount of the bill would have to exclude an element of the bill which forms a crucial part of the calculations and which must be assessed by the court. Yeah. But the solicitors will say that that isn't part of the bill for the purposes of section 70, brackets 10. And as one can see, when one gets the breakdown of the bill, the breakdown includes that 1,700.
Yeah.
It has to.
Okay.
So it is essentially the bill includes this figure, and needs to be assessed as a totality, and we'll agree that that's the figure, but ultimately it's a different figure which is not on the bill at all. I mean that is, and when one is dealing with, I would submit, solicitors who are learned in the law and lay clients, that is not, in my submission, acceptable. No. There isn't any prejudice to the solicitor, because what they should have done here, they accept that the bill is the actual figure, and then if they want to make arguments under the 1/5 rule, the special circumstances, then they can. But what they can't do is suggest that the bill is somehow a different figure from that which is being assessed.
So if at the end of this, going back to a point I put
yes.
to you earlier, this bill had said at the bottom, it had a rubric that said, because we are only charging you £1,571, which has already been paid, the amount of this bill is £1,571 already paid. You'd still say, would you, that the amount of the bill was £2,700?
Well, in those circumstances, what would happen was, if there were any issues as to the amount of the bill, that would be dealt with at the first directions hearing. So that would be dealt with in respect, when the claim form says the bill that we want to assess is X, what ordinarily happens is, if there's any issue as to what that amount is, the solicitor will say, no, it isn't, it's Y. Now here they said, yes, we agree, it's X. But there is an issue with that in this sense, that if the actual bill itself is said to only be £1,500, how does one assess the bill, which includes an element of £1,717?
Sorry, I still don't see what the problem is. Can I take Mr. Marvin's example, which was rather simpler, which was, we have got on our books £10,000, let's say 100 hours at £100 an hour.
Yes.
Actually, we're only going to charge you 7,000, so we put in a bill which says £10,000 base costs, but £7,000 already paid, nothing to pay. And then the breakdown explains how the £10,000 is made up, hour by hour. 2 hours and 12 minutes spent writing a letter and so on. When you come to assess the bill, obviously what the district judge is going to do is look at the hourly rate and look at the number of hours to see whether the 10,000 is justified. And he may say, actually, it's only 8,500 that's justified. But that doesn't affect the fact that the bill was 7,000 and the amount the solicitor keeps at the end of the day is 7,000. But why is the mere fact that in order to do the exercise you have to go through the 10,000, why does that mean the 10,000 is the amount of the bill, because it quite plainly isn't.
Well, that would be a classic but say figure.
No, it's not a but say figure, because as I read the old authorities, the but say figure is, I am entitled to 10,000.
Yes.
If you pay me 7,000, then I won't go through the taxation. But if you go through the taxation, I'm going to take what I can get.
This is different. This is saying, I might have been able to charge you 10,000 in my Lord's example, but I've only actually charged you 7,000, which is the most I want, full stop.
But
that's not but say, that's just saying I was always prepared to walk away with 7,000 which you've already paid me. Well, end of story. If the client chooses to go to assessment, solicitor doesn't need an assessment in those circumstances.
Well,
if the client chooses to go to an assessment in order to establish that the actual amount should be less than 7,000, that's for the client.
But that's not the case in Re-Paul, because in Re-Paul it is quite clear, because a cash account has been sent, that the lower figure was the only figure the solicitor was ever going to charge. But that didn't make a difference. If a higher bill it was still considered to be a but say figure. There is the obvious
Yeah,
case.
but it wasn't on the face of the bill.
No. Well, there were two. All the authorities usually involve two separate invoices or
Two
bills.
separate documents, exactly.
Indeed.
But that's why Mr. Marvin posited the case where it's quite plain on the statute bill, this is all we're asking for.
Yes.
You've paid it and we don't want any more. Even though we could, being transparent and so on, and giving a discount, both of which he said were good things, we could have justified 10,000. And if you go to assessment, we will try and justify 10,000. But all we want is 7,000, and we're not asking you to pay any more because you've paid it.
Well, there's two. I would submit two answers to my Lord's question. The first answer is if we are looking, if we're casting an eye over this bill and asking ourselves, well, what is actually payable by the client, then that is not the 1,500 figure, it is the 455.50 figure. That's the first point.
But it's been well established for a very long time that if somebody else pays your bill, it's still treated as part of the amount in the bill. And that must be right.
That is right, but this is what the position that we're in is a lay client looking at this bill and considering, for the purposes of for the purposes of the 1/5 rule, what the bill totals. But my Lord, there is a more fundamental distinction between the example that's been given and this example, and it's going to be, I'm afraid, become one of the greatest hits of these submissions, because it is to do with the success fee. Because in my Lord's example, the £10,000 figure becomes completely irrelevant at the point at which £7,000 is said that's all you need to pay.
No, it doesn't, because in my Lord's example, there's then a breakdown which breaks down the £10,000, and the argument is that in the example that the client is trying to establish before the district judge that 7,000 is excessive, because 10,000 by definition is excessive. So the district judge goes through the bill, saying, as my Lord says, you too much for this, too much for that, too much for the other. You could never have charged 7,000, let alone 10,000. The amount of the bill should be 6,200.
Well, in that circumstance, if the solicitor is only saying that the amount to pay is £7,000, then the breakdown wouldn't have to include all of the costs. I mean, it can, but it wouldn't have to, because all they need to justify is the £7,000. But even if they did put in a breakdown for £10,000, the purpose of that, the status of that £10,000 figure is completely different to the status of the 1,700 figure here.
But you're going round in circles.
I am, my
Dan.
Lord, but
the argument is that you cannot conduct a proper assessment unless you know the base costs, and in this case the success fee. And in the other example, it's the same really, except it's just the base costs. Because the assessment will be of the £10,000, and if you want to have a breakdown of £10,000, you've got to say it on the bill.
the assessment in my Lord Nugee's example will be an assessment of £7,000.
No, it will be an assessment of whether the 10,000 is justified, and then at the end of the day you'll look and see if it beats the 7,000, which is what's actually been charged for the purposes of section 79.
One assesses the actual bill, the statutory bill.
The success fee is not, it's not the subject of some separate magic assessment.
No.
It's entirely contingent on
Yes.
on what are the
it's all part of the
recoverable
profit
base
costs.
But if we take the
So you'd have to always assess what the recoverable base costs were.
but the 10,000 and 7,000 example, my lord's example,
Yeah.
the £10,000 figure is only a figure that exists in order to justify the fact that the £7,000 build is reasonable. That's the status of the £10,000 figure. That is different to this example.
No.
The status of the 1,700 figure is not just a notional figure to consider. It is actually an assessment which is required in order to produce the success fee figure. That is fundamentally, in my submission, different.
I've not understood what the difference is. If you accept that your success fee is going to be 15%, what you're saying is if I win the case, every hour I spend and charge £100, I can get £115 for. It's just a 15% uplift on the base figure. That's all it is.
It is.
So there's no difference between calculating the base costs and then adding 15%, upping the hourly rate for the base costs by 15%. It produces exactly the same result.
Well,
The effect of Mr. Justice Lavender's decision, reversing the district judge and unappealed before this court, is that the 1717 was recoverable.
Well, actually, I think he said 1080, but it
The
doesn't matter
1080
because the 1080 is the base
1080,
cost.
yeah, sorry.
You add 15% to that, which is another 100.
Yeah, the 1080, yeah, sorry.
which produces
62 produces 1242 plus VAT.
the 1080 would produce a success fee of £162 rather than
Yes.
200.
And when you
But
add
it
on
doesn't
VAT,
matter because once you've got your base costs of 1080 and your success fee of 162, and you look at how much, this ignores VAT, but you look at how much has been paid by Aviva, which we know is 750, there's more than enough to justify the 455 figure.
But that requires, my lord, that working out that my lord has just expressed requires the client to do something which they simply cannot do on the basis of this.
but this is
What
all-
does it
no,
require
because it
to
all
do?
happens in the assessment.
I don't understand what it is
It's
requires them to do. They need to look at the
Well,
base costs.
I mean, the before we sort of descend
Sorry.
into an argument, your argument is that it is different because the client has to see, and the court needs, for the purposes of the assessment, to see what the solicitor has charged for,
Yes.
has done. And it may be the solicitor's not agreeing to 15%, he might be agreeing to 43.25%, or he might be suggesting 2%. It just, you don't know unless it's stated. And you say, unless it's stated, it can't properly be assessed, and therefore it has to be there.
Oh.
And therefore the amount
Yes.
of the bill includes those
The amount of the
figures.
bill is, as it were, the
Yeah, I
workings
mean,
out.
I think the argument's not changed. It's just, if I may say so, a slightly semantic one.
It may be. May I make one final point in the
Yeah.
hope that I can address my Lord Nugee's point. The point, I suppose, is ultimately this. In the 10,000 example, the 10,000 is never charged. The 7,000 is charged because what they say is 10,000 has been incurred, but we're charging 7,000. In this case, one has to charge and then discount 1,700 because one charges it, works out the success fee, and then discounts it.
Well, that's the
it's
argument
also
about recoverable
semantic
costs.
again, but anyway,
That-
yeah.
that-
Yeah,
but
okay.
that's an important.
I see the point.
It may be semantic, my lord, but
I see
I
the
say
point.
that's an important distinction.
Yeah, okay.
Mm.
Are there any other points of reply? No?
My lord, those are.
Okay. And nobody wants to say anything else? I mean,
I'm
sure.
not, thank you.
Okay. Well then, it only remains for me to thank you all for another interesting argument. We'll take time to consider our judgments. I think you all heard yesterday what I said. Mr. Marwin didn't, but he'll know about Counsel General for Wales and the embargo and who's to see the judgment. You'll get all that. You'll agree costs and also an order arising from our judgments. And if you can't, that'll be done in writing. And meanwhile, I thank everybody once again for an interesting week and wish you all a pleasant weekend.
Thank you.